Mr. Putnam.
May it please the court, counsel. My name is Dale Putnam. I represent the appellant, Luana Savings Bank. This matter has had some trips up and down also. It started out with a motion for summary judgment. And I guess, so we're all on the same page, we have that in this case. The trial court took the motion and granted the motion, filed on behalf of the defendant. The reason for filing the motion, or the reason of accepting it, was because the defendant, or the plaintiff, excuse me, the bank, couldn't be the homeowner. That was the sole reason that he granted summary judgment. There's a couple peripheral issues with that, but we'll probably get to those later. From there, we asked for the opportunity for an interlocutory appeal, which was granted. We went to the Court of Appeals. Court of Appeals said, we don't want to touch this issue, and we're here now because of that. We think it's time that the implied warranty was expanded again. We think there's no reason why it shouldn't be. Why people can build houses, some people, and they can't be sued. Why others can build houses and they are sued. It just doesn't make any sense at this point.
Counsel, can you cite us any case from any jurisdiction that has extended the protection of the implied warranty of good workmanship to a foreclosing bank?
No, I can't, Your Honor.
Isn't the sort of the origins of this theory was from the implied warranty of habitability in Meese v. Fox?
Correct.
And then in Kirk and then later Spite, we extended it to homeowners and then subsequent homeowners. But isn't the theory that they are living with the problem and your bank's not the homeowner?
Well, we take it, and the reading of the cases, that it's not living with the problem. It was more that they want to protect the homeowner, the innocent homeowner. And I've got just a little chart here that would basically show that the innocent homeowner is also a bank. It's also a father-in-law. It's somebody else that won't trigger the implied warranty. But then we get down to, is it also including the bank here? And every mark is checked. Innocent buyer, well, the homeowner is, that's what we're here for. The bank, innocent, they don't have any special knowledge. They don't build houses. They don't build 12 plexes. They're not in a position where they can say something's done right or wrong. And in particular, in this case, this building was built 2 years before the bank ended up with title to it.
Usually, I mean, if I go and I buy a home, what I'm expecting to get in return is the home. That's what matters to me, the quality of the home that I'm getting. If I'm a bank and I'm lending money to someone, usually what I'm looking at is the creditworthiness of the borrower. Yeah, I want collateral. I want good collateral, but my focus is on the creditworthiness of the borrower. So isn't that a different situation? Because they're a sophisticated commercial entity. They have the opportunity to evaluate the creditworthiness of the borrower, and for that matter, they also can look at the collateral. But that's kind of secondary, isn't it?
Well, we believe the collateral is paramount, and that collateral is what's going to determine if a loan is going to be made. If it was something that was easy to see, if there was a sunken hole in front of the front door, that's a different story also.
Let me ask another question. Why didn't your client get an assignment of any claims the Walls might have against ProBuild?
I don't know that that issue came up whatsoever.
One more question about the record. I see that there's sort of a contract for ProBuild that was in the record, and it's this one-page labor and materials. You're familiar with it, right, Mr. Putnam?
Yes.
Now it says on the front, subject to all terms and conditions on reverse side, which I'm guessing is the warranty information and any disclaimers, usually is, and that sort of thing. But when I went through the record, I couldn't find the reverse side. Is it in the record?
It is not in the record, Your Honor. It was found afterwards. Mr. Anderson brought it to my attention. We had both looked at it, and it didn't appear that it added anything at all, one way or the other, to the case.
Isn't one of the rationales for allowing homeowners to sue under the implied warranty is they don't have the bargaining power or the expertise of a professional builder? How does your bank fit within that rationale?
Again, we're at the position where we have our sheet and we go down it, and it's got everything. The inferior position of the borrower, which is what you're talking about. The bank, again, is at that same thing with the inferior position, because the bank isn't qualified to build a house. The bank doesn't know if there are structural problems. The bank doesn't know whether there are conditions that are inducive of having mold. None of those things are known to the buyer, and especially, again, in this case, where my bank didn't even get on the property, didn't own it until 2 years after the building was built.
Well, maybe before you foreclose on property, you ought to have property inspected.
The house wasn't available to be inspected at that time.
At the time of foreclosure?
Correct.
What did you have at the time of foreclosure? What was the status of the apartment buildings?
The apartment buildings were signed, the two new ones, correct? They were signed for by Ken Walls. He was the apartment manager. He signed the document, signed the contract to get it started. The bank had nothing to do with the contract. Other than the bank had a lien on the contract, the bank had an assignment of the contract, the bank had an assignment of the payments, the bank had a note, and the bank had a mortgage. The bank took 7 steps to protect its interest and ends up with, potentially, depending on how you folks rule, will end up with an asset that has over $500,000 of debt, of damage due to shoddy workmanship. Well, shouldn't the question be, though, we get back to this question, shouldn't the question be, why are we allowing this to happen? Take aside it's not a bank. Let's say it was a father and there's an LLC, and he gets this building and he puts it in the LLC for his daughter, but he doesn't live there, so they don't get to claim it. Shouldn't the question be, was there a problem? We're looking at this inferior position. We're looking at the bank relying on information that's not known, or having to rely on information that's not known. They're in the same position as the home buyer. Latent defects, same thing. They can't tear down the walls and find these defects during these 2 years. We're just asking that the bank and other borrowers have the same protection.
But it really, they don't have the same interest, and I think from a policy standpoint, if there wasn't a deed in lieu of foreclosure, the bank would have no interest whatsoever in the quality of this construction, except that they got it back. If it was the borrower had continued to make all the payments and sued the subcontractors and the contractors for faulty construction, which they would certainly have a right to do, the bank wouldn't care. They wouldn't intervene in this. They wouldn't have any interest in here. So they don't have any interest until they get the property back. Now all of a sudden they want the interest and the protection, but until they took the property back, they really don't have any interest in the quality of that construction, do they?
Yeah, we believe they do, because they have the note and all the assignments of all the documents.
Well, but they have it, but as long as they get paid, they don't care.
Well, it's always nice as a bank to get paid. I would grant that, Judge. But again, I keep going back to my sheet, and it keeps coming up that a independent, a regular, normal person isn't any different than the bank as far as whether the implied warranty was met.
Let me ask probably an easier question. Is there any reason not to recognize the implied warranty when you have a multi-unit apartment building?
No. None that I'm aware of or that we have seen from any of the cases. Cases throughout have indicated that multi-units are okay. Again, it's the ultimate end result. Do we have a good unit? If we have a good unit, does it make a difference if it's a duplex or if it's a sixplex? I mean, that's what we're trying to get. And if the contractor can't build a good unit, uses shipshod workmanship, why should we allow the contractor to get paid? Why shouldn't we allow the homeowner to be the speculator to be? Why shouldn't we allow them to have a good building? Why shouldn't we allow them to sue if they need to do so and let a jury demand?
But why equate a foreclosing lender to a homeowner? When we're dealing with people in the business of lending money or developing real estate, aren't they in a position to protect themselves through express warranties? And the implied warranty is a judicial creation to protect innocent homeowners.
If you're asking, are banks in the business of providing legal advice, that would be a no. And they shouldn't step in and try and provide legal advice.
But don't banks typically protect themselves with a lot of boilerplate on their loan documents?
Yes, but the problem comes when you have an asset that has went down in value, like in this case. This property is encumbered by over $500,000 now because of shoddy workmanship.
Counsel, if I'm recalling correctly, I think our imposition of this implied warranty to date has been in cases where the defendant was the builder vendor, that is to say, owned the property upon which the allegedly defective structure was built. That's not the case here, right?
Correct.
Okay. Why shouldn't that make a difference as we're exploring the merits of your case?
If you look at the Spate ruling, the 5 prongs were different regarding that came out of Kirk. We don't think it makes any sense that it has to be on the builder's property. We just don't think that would be correct or appropriate, and we think that's why it was left out in the Spate property. Excuse me, the Skate ruling. We think that this court could enhance the quality of looking out for the little guy, the borrower, the person that's going to go into the property, who's going to end up with it, by removing the first 2 prongs of Kirk and Spate. We think that would be an appropriate use of this court's power, and we think it would be good for the consumers to know that this court and the state of Iowa is looking out for them and trying to look out for them. One last thing is, we think also, depending on how this court rules, if you overrule the bank, we think there could be a chilling effect throughout the banking industry. If I'm a banker and we've got this problem that we're going to come up with 7 documents securing payment, and we still can't get payment because we can't sue the one party that we could get payment from, we're not going to make a loan. The next bank may not make a loan. The next bank may not make a loan, and so on and so on.
But you could make a different economic argument. You could say the bank will be more careful when it makes a construction loan about monitoring the quality of construction in order to assure that its collateral is protected. Couldn't you make that argument?
Well, as you know, you can make any arguments. Let's say the banker's out there, though, doing what you've asked him to do, monitor the construction, and the building doesn't turn out the way it should anyway, irregardless of the banker employee that's watching the property. I mean, they're not going to hire a contractor to go out and watch another contractor. That individual says, well, wait a minute, I think the bank gave me some advice and told me that it was okay that we put this door in here. And because of that, the person fell to the floor and dropped down 2 stories and was seriously hurt. I think that's just inviting more litigation.
So counsel, you're also suggesting, I take it, that the other problem is that if you are expected to have a monitoring contractor who would know about the quality of the construction, that would increase substantially the cost of lending.
It would have to. And nobody does that. I mean, if that was a proposal or a proposition or practical, the banks would be doing it. See, my time is almost up. Any other questions?
Thank you, counsel.
Thank you.
Mr. Anderson.
Excuse me, may it please the court and counsel. This is a case about, I'm Sam Anderson, by the way, represent ProBuild, the successor in interest to UBC, who entered into the building contract to build 2 apartment complexes for Ron Walls. This case is a case about the bank's disappointment in the condition of the value of collateral it got back from a borrower upon a defaulted loan. And the bank, through this action, is attempting to maximize its recovery on the collateral received from the borrower. That's the framework that this case is set up in. There's no dispute that there was never any contractual relationship between the bank and the contractor, my client. There's no evidence that the bank ever inspected the properties as part of its determination of whether to accept the properties as collateral to secure the loans in whole or in part. The bank never set any standards for what it expected in the apartment buildings to be used as collateral for it. These are all things the bank could have done. In the Kirk versus Ridgway case, 3 considerations were listed as reasons for expanding the contractual implied warranty to the homeowners in that case. The first was the idea that, you know, these prefab homes where people were building spec homes and giving them to, or trying to sell them to consumers to buy the homes, that the homes were more like goods, like cars and machinery. The second point raised was the increasing interest in the courts to protect purchasers or consumers of goods and products. And the third was the complexity of home construction, which made it harder for the average buyer to discover defects in the construction. None of these concerns that were raised by the court in Kirk versus Ridgway exist in this case because the Luana Savings Bank, what their goal was here was to, I mean, supposedly a bank, when it takes on collateral, their concern is to make sure they have enough collateral to secure their loans, to feel comfortable with their loans. They could have done any number of things when they took this on. They could have inspected it. They could have demanded that whoever owned it at the time make improvements in order to secure their loans. They could have taken on additional collateral to secure their loans. There's a number of things.
They insisted that Walls, when he negotiated the agreement with ProBuild, made them a beneficiary of any warranties? They negotiated.
Yeah, they could have done that too. They could have had Walls assign whatever causes of action he had. In this case, I think there's an affidavit in the case that Mr. Walls didn't have a problem with the construction. But he could have assigned it just to get the bank off his back. Whatever cause of action I have, here you go.
And that didn't happen in this case, did it?
That did not happen in this case. And this apartment building was built as a service to Mr. Walls. There is no basis for treating this building as a product, like a good for a sale. That's one reason that the Kirk wouldn't apply. The bank has no interest in owning the property. The bank admitted, all the parties to this contract admitted, or to this case, admitted that the bank didn't want it. The borrower didn't want the bank to have it. ProBuild didn't know about the situation of the loans. The other thing is we have no consumer here in the context of the courts wanting to protect innocent consumers. In fact, banks are considered sophisticated enough that there are consumer protection loans to protect consumers from the banks. The bank has no disadvantage here for the reasons I've already mentioned. So if we go to, it was to protect this finite interest of home builders who are buying spec homes, basically, that I think the court created the rule in Kirk versus Ridgway, and they created the 5-step elements very carefully. And I think if the court were to extend this case to apply here, you'd have to throw out all 5 elements and come up with something totally brand new, and I have no idea what that would be. You'd have to throw out almost all the ideas of natural contract language or contract principles of privity. You would have to throw out standard ideas between even the warranty issues between a contractor and somebody that's having them build a house for him. And you'd be throwing out tort law, things like the economic source rule, and the idea that contract law is to protect the parties from disappointed expectations, whereas tort law is more geared towards the occurrences, accidental occurrences that could have been foreseen and protected against through proper care.
Counsel, you've given us a lot of arguments why the bank is not a proper plaintiff. Let's look at the other side of the V. Is there the defendant in this case the right kind of defendant for this theory? Are they a builder vendor?
No, they're not a builder vendor, and that's the second element in the Kirk versus Ridgway case, and they're not a builder vendor. They did not build this to sell and make a profit on from a standpoint of speculation or whatever. Basically, Mr. Walls came to them and said, I've got 2 other apartment buildings right here. I want you to build these 2 buildings just like those 2 buildings. And so they provided this service to them. And so that's the other thing. They built this the way Mr. Walls wanted it built. And the fact that the bank comes in later and says, well, geez, this isn't the way we would like it built. I mean, for us to maximize our recovery on this, this property we get back, I think we're going to have to replace all the windows, put higher quality windows in. We're going to make it more energy efficient so we can get more bang out of our buck. Well, that's not what our people, I mean, there's decisions that are made by someone who hires a contractor to build a place, economic decisions, whether you build the Cadillac, whether you build a Pinto or whatever. That Pinto's probably not a good example, but there's economic considerations that go into that is different than someone just coming in and buying a car or looking through a house and saying, yeah, I like this. I want to buy this for a home I live in. So it doesn't meet, they are not builder vendors.
Counsel, would Roque have a cause of action against your client?
Well, it depends. The confusing thing to me is that the contract was with Ron Walls, not with Roca, but Ron Walls was a principal of Roca, and theoretically, if the court considered them one and the same, there would be the basic. I mean, with any construction contract, there is an applied warranty that the building will be erected in a reasonably good condition and workmanlike manner, and will be reasonably fit for intended purposes. And it's my understanding that with the Kirk versus Ridgway, in extending this beyond contract realm, they took what exists for purchases of homes in that situation is merely an applied warranty that the building was to be erected in a workmanlike condition. They do not get the reasonably fit for intended purposes, because that's not why it's built. But I think, assuming that row cause is the same as Ron Wall's, then yes, they would have a cause of action.
And is Mr. Putnam right that the back sheet is
Yeah.
not in the record and doesn't really shed any light here?
It doesn't. I agree with that 100%. That showed up after the original hearing, was a big gulp, and we looked at it, and we both agreed that it didn't shed any light on anything. So with that, I just think that the court should be careful in considering this, because you'd be throwing a lot out the window if you extended these protections all the way to a bank. And you talk about there is a restatement third of torts that talks about liability for economic harm for negligent performance of services. And even that section warns about going too far and going beyond the reach of reasonable expectations. And when people contract, when contractors make decisions to build for someone to a certain specifications, they're not foreseeing that somebody else might come in and want a different kind of building that they're building for Ron Walls. And if
Could you give us the cite to that restatement provision?
Oh, it's restatement third of torts, liability for economic harm, section 6, negligent performance of services. And by the way, that section pretty much says that doesn't apply to a case like this. As a matter of fact, it didn't even go as far as this court has gone with the Spike case. It would have rejected that. But the warnings it gave in some of its examples, I thought, shed light on it. And that's the only reason I brought that to the court's attention. And that's all the arguments I have. If you have no more questions, I'll go ahead and sit down.
Thank you, counsel. Rebuttal, Mr. Putman?
First of all, we take issue with Mr. Anderson's claims that the bank now wants something different. They wanted a house that would withstand time more than 2 years. 2 years after they took over this place, they find it's got black mold. They find that there's holes in the ceiling because they didn't cut the pieces to fit right. The most easy thing in the world is cutting the pieces to fit right. They didn't do it. The bank didn't come in and say, we want something different. We want central air conditioning. We want this. We want this. The bank came in and said, we want a building that is habitable, like we all do when we have our contractor do something for us. They had that right, and they didn't get that right. The question came up about assigning. I think, Justice Mansfield, you asked about assigning something. That's assuming things that aren't in the record, because one of the reasons why you wouldn't need or ask for an assignment is if that entity was also had judgment proof and or had filed a bankruptcy. When you're talking about Mr. Walls.
Right, all right. Well, let's say he's filed bankruptcy. You could still buy his claims or ask the trustee to abandon his claims against the ProBuild in the bankruptcy. I mean, my experience representing banks and parties adverse to banks is when there's a party that's in debt and they're in default, the bank usually goes, full bore after them and gets, if it's an apartment complex, gets an assignment of rents, gets in fact steps into the shoes of that borrower as quickly as possible, and that's why I just wondered why it didn't occur here.
Well, it did. The bank became the landlord on the property and hired an agent to lease it out and do the work and took the rent checks. Once the bank got the property, that's exactly what they did. Then they find out 2 years later that they got a property that wasn't built properly. So we're still coming back to, and I know it'd be nice just to push this in a little box or a little hole, but the problem is we're still having faulty construction. we're having, shipshod workmanship. This case shows it, and the exhibits will show it. So we have this happening, and we're not addressing it. We're saying, well, you know, it's too bad, so sad, but what I tried to demonstrate earlier.
Couldn't you have taken an assignment of any, you could have taken an assignment of any claims that they may have had against the contractor, though, couldn't you?
Could we have? I don't know. I mean, theoretically, we could have.
And I'm not saying it would be effective, but I'm
Right.
just saying that's an option, just as Justice Mansfield was mentioning the whole idea about you just take the assignment, you take over all of the obligations of the borrower, and couldn't that be a condition if you accept back the deed in lieu of foreclosure then, that is any types of claims that you may have? Looking into the future, I understand you're trying to look
I think we have
ahead.
the same litigation, only worse, because they're not going to agree that that's binding on them. UBC's not going to say, well, you got that piece of paper from ROK and it's binding on us. One other thing I wanted to address briefly, there were 3 causes of action. One was kicked out, no dispute about that. The other one was a third-party beneficiary claim. It wasn't addressed by Mr. Anderson. I think the record is clear on a summary judgment especially. Our brief sets out what we need, and we've more than met that.
Do you have, where did the Court of Appeals go wrong on deciding that third-party beneficiary theory?
It wasn't clear to us where they went, other than that they said that they affirmed the grant of summary judgment on that issue. We think the case Midwest Dredging, which we cited, it talks about language of the contract and circumstances surrounding that contract. The and would be the 7 to 9 different documents that we've rattled off that everybody was aware of, everybody knew existed, everybody knew were all going to the bank. In fact, that first payment was $100,000 written on the bank's, out of the bank's account. So we think clearly a jury, we think we've raised a fact question, and we would ask that that issue at least be overturned. We'd ask that the court take out count 1 and 2, or the first 2 issues in the Kirk and Spate case, and I think that would be easy and be clean, and we'd ask your consideration. Thank you.
Thank you as well, Mr. Putnam. The case is now submitted, and we'll hear the arguments in the Alta Vista Properties, Inc. case.